is set for a hearing today. Back on December 4th, the court issued an ex parte order regarding custody and parenting time. Mr. Brewer's filed an objection to that order. So this is set for a hearing on that today. Mr. Brewer, can you tell me what your objection is to that order, please?
Well, I object you suspended my parenting time, and I want to object to that. I don't know, there's quite a bit here going on. Mr. Aneski has a PPO against me. I seen her at Walmart, if you remember, and she gave me our son when the PPO was in order, and then filed a violation of PPO. We came in front of you. I admitted to it. I was found guilty. The only thing the violation was text to her regarding our son, who was in our custody, in my custody, excuse me. There was no court order in effect when he went into my custody. And then somehow she slipped through the custody hearing we had a few days later, and this custody hearing went in effect. And I immediately filed papers to change custody and visitation. We came to court multiple times. She never brought up in court to you, to nobody, to say, hey, you need to give him back. I've never been through this, Your Honor. I didn't, I was waiting for her to say I want him back. And then she did file papers saying that I was in violation of my parenting order. I came to court. We were in front of the magistrate, or another judge, Your Honor, and I never had a chance to speak. He opened it up with, do you want to go to mediation or to court? And they said court, and he set a court date, and it was over. I had no time to talk, to say anything at that referee hearing is what it was, Your Honor.
Yeah, I'm familiar. I watched the video of that, so I saw what happened.
Yeah, I guess I was on meth, Your Honor, because I just cannot believe that she hired a lawyer. I can't believe that she wants to fight me over my 4-year-old. The 4-year-old that I've raised, that's been with me every day. Whether, we go to my shop every day of his life. He goes to my shop with me. She worked, and if she didn't work, she went to my shop with me. And now all of a sudden she wants to split up and take my son from me. I just, I understand that there is an order in effect now that I have to follow, which is every other weekend. I understand that. And I'm working on the filed papers to change that. So I do understand that, Your Honor. But I'm not going to keep my son. It's hurting my 4-year-old son is who's being hurt by not seeing his father.
Okay. All right. So the concern I have, and I put it in the order, is that if you have parenting time, that we're going to end up in the same situation where you're not returning the child based on what happened before.
Right. But I would never do that, Your Honor. I've been warned. You're warning me. I understand that. I understand that I have to follow that order until that order is changed. I thought that when that order was put in effect, Your Honor, and I filed papers to modify that order, I thought I read in that paperwork that if it was a new order, it didn't apply. Like the order was brand new. I was under the understanding that it didn't apply. And like I said, she never asked for our son back. I mean, she, I just don't know. Okay. I'm just, all I know is I will follow the order every other weekend, and that this is killing me and it's hurting my son. I know my son is hurting from this.
All right. Thank you. Mr. Straw.
Thank you, Judge. I appreciate the fact that you reviewed the referee hearing, Your Honor, and I think that in doing so, you probably find that Mr. Brewer's statements today are disingenuous with this court. I mean, I had the distinct impression that he knew that there was an order, he knew that he was in violation, and he knew that he wasn't going to have to face the music until February when it came to returning the child to his son. I mean, he was sneering to the court. He was, he loved the fact that the date was several months out from when we were last before the referee. So his suggestion today that he's going to follow the order and it was just a mistake that he had made in the past, I think is without merit. In reviewing your order, it looks like it's your expectation that we'll have an evidentiary hearing before the referee in February. And at that point, the referee can make a recommendation as to what's in the best interest of the party's 4-year-old son. So I would ask that the court essentially allow us to have that hearing in February and allow the referee to make a recommendation and see where we go from there. The only other thing I'd mention as kind of an aside is that Mr. Brewer did file his objection in a timely fashion. Unfortunately, he didn't serve it on me as counsel of record. My calendar was open and I was able to attend today's hearing, but I wasn't aware of the objection until sometime after it was filed and my client brought it to my attention. So that's just an important piece for Mr. Brewer to understand if he's going to represent himself in these proceedings, that when he does file anything, it needs to be filed with counsel of record also.
All right, thank you. Mr. Brewer, anything you wanted to say in response to that?
Well, the only thing I had asked the county clerk and she advised me just to mail it to her known address. So from now on, should I just file papers to his office? Is that what he's saying?
Well, yeah, he needs to get a copy of everything that's filed.
Okay. I'll make sure he does.
So, all right. So again, I did review the hearing that was before the referee, and it, I watched it, and it was made very clear, Mr. Brewer, that that you were supposed to return the child, what the current order was that was in place.
Okay.
And my interpretation of that hearing was that you were going to refuse to do that, even though you were aware that.
Excuse me, I'm sorry, Your Honor. I did not mean to interrupt you.
Yeah.
Your Honor, if the referee that day would have told me to return my son, I would have returned him. I understand what you say goes. There is no doubt about that.
Yeah. So, I mean, I watched it. I saw everything that was said, and that's my impression of it. And so that leads me to continue to have the concern that I had at the time that I entered the order, that if you have custody again for parenting time until this is worked out, that we're going to wind up here with another issue, a motion from Mr. Schrod. I'm just not going to put everybody in that position of creating an issue. So,
okay.
So
all right.
Court's order. I've heard your objection. Court's order from December will remain in place. The parties will proceed to hearing as currently scheduled, and we'll go from there.
All right. You have a good day, Your Honor.
All right. Thank you. That's all for this hearing. All parties are free to disconnect at this time.
Thank you, Judge.
Defendant has a balance exceeding $20,000. He has the ability to pay out of currently available resources, and he has recently made a payment on another domestic relations case. He has not made diligent effort to pay all or more significant portion of the amount owed. He was given the option to make a purge payment before today's hearing in the amount of $2,500. This morning, Sean did present at front of the court to make a $1,000 payment. He has also, in the meantime, requested a review of support. With that review, he submitted limited information, so it would be beneficial for friend of the court to have some more information on how to go about the support recommendation for his income.
Okay. All right. Ms. Nolasco, was there anything you wanted to say in this matter?
I know the last time we were in court is that it's, the 2,400, and then he hasn't had any kind of payment at all before that. I understand that he had some kind of circumstances. So right now I'm just trying to see what we can do about this.
Okay. All right, Mr. Duchesne, so the court is going to set this over for 30 days. Although, you didn't make the $2,500 payment, you did make a $1,000 payment. So the court is going to set this over for 30 days, and the court will make a determination as to the contempt at that time. Ms. Krause, does he need to contact friend of the court regarding the additional information, or is that something that you can state for the record here today?
If I could state for the record, the questionnaire that he did submit had a lot of information blank. This morning, he did submit some information from 2019 through the present, which he had indicated on Friday that he hadn't had any income. But today on the paperwork, he said he completed a flooring job that he received $2,000 for. So I'm looking for his income amount to input for that calculation to get it out.
Okay. Mr. Duchesne, can you address that for us?
I'm not sure which part, Your Honor. I'm sorry. I was listening, but I'm not sure what exact part you want me to address.
Can you provide
Monthly
that?
income.
Yeah, can you provide that information to the front of the court?
I did this morning. I wrote some stuff down on a paper. I could go over it again if you want, but so as of November 19th, or as of November 9th of this year, I broke up with my girlfriend that I was living with, and now she is keeping all of my stuff, and I am suing her. We go to court next Monday. So as of November 9th, almost 60 days ago, all of my tools were taken from me, and I can't even work. So I was just able to complete a flooring job with the help of some other guy and his tools. I made $2,000 and I turned over 1,000 of it this morning. I just got that money on Saturday. So when I talked to Ms. Kraus on Friday, I did not have that money. So I didn't count eggs that weren't hatched, I guess, Your Honor. And then this morning I paid half of the money that I received.
So Ms. Kraus is indicating that you left a lot of information blank on that form that you turned in. And then Ms. Kraus, again, for the record, can you state exactly the most important information that you need from him?
His gross income monthly, so we can do the recommendation.
So
Okay.
Mr. Duchesne, you need to provide that in writing to the front of the court. Otherwise, nothing's going to get adjusted. You won't even be able to have it considered. Okay.
Yes, sir. Can I say one thing that I would like to be on the record, please?
Yeah.
So obviously I knew that I had a son and that I wasn't paying child support, but I had never gotten any information. In 2020, I would never received any information when this child support stuff started. I didn't know anything about owing child support obligation until less than a year ago. But in 2020, I was working a job making $14 an hour, paying child support for 2 children right here in Gaylord. So what I don't understand, I can't seem to calculate it in my head how this number was ever even brought up. My obligation for my son here in Gaylord is $179 a month. Then, so how does the next kid, the third kid, be triple? On top of that, I'm only making $14 an hour. So I feel like the $20,000 number is inaccurate. And so I don't feel like it was calculated correctly, because I don't believe it was based on $14 an hour at the time of the case. So I feel like I owe more than I should. And it seems unfair, I guess. And I don't know how better to explain it. But I do believe I owe money. I'm not stating I don't. Oh, I know I owe.
Well, if you want to challenge the amount, there are ways to do that. You just telling me that here on the record, is not going to be sufficient. You need to challenge the amount. You're going to need to file a motion in the front of the court. You may need to get an attorney to help you with that. But if you want to challenge things going all the way back to 2020, you're going to have to do a lot more than just make a statement like this here on the record, because I have no idea, based on what you're telling me, whether it's appropriate or not. So that's something that you need to be proactive about, because based on the information that we have, and the court has followed the law in terms of what it needs to charge based on the information that was provided to us. So if you think that's wrong, or you weren't provided appropriate notices or so forth, then you need to be proactive about that. Start filing some motions to get things changed. Otherwise, it's not going to change. And just saying it on the record is not sufficient.
I did file a motion. I did file a motion regarding support. That's in the works right now. I got another one this morning when I was at their office. I will be more proactive, and I apologize for not being more proactive.
Yeah. So, if there was something wrong, we'll look at it based on what you filed. And obviously, if there's a mistake made, we'll correct it. But if there's not, then we're going to go forward. So either way, you need to provide the information that Ms. Kraus has indicated within the next 30 days. Can you make another payment within the next 30 days?
I'm not sure, because I'm fighting another child support case this week that also needs to be addressed. So I don't know for sure, but I will definitely try. If all of my personal property wasn't being held by my ex-girlfriend, I could sell my personal property and make payments. So I'm kind of screwed in the sense that my ex is being spiteful and holding all of my stuff. So I can't even sell my assets to even try to make any payments on because I have nothing right now, which sucks. And that court case is on Monday. I'm suing her for $7,000 because she has all of my tools. I've been a flooring guy for 20 years. I'm a felon. I can't go get a job at just most places. So I've been doing my own little flooring gig for a long time. And now it's just, I just can't do it because all my stuff's gone.
Ms. Kraus, is there a monthly amount still charging on this?
$513.
$513, okay. All right, so the court's going to order, number one, that you provide that information within the next 30 days. The court's going to order that you make a monthly payment within the next 30 days. We'll set this for hearing at that time. If neither or either of those things is not done by that hearing, then the court will proceed with contempt sanctions, and we'll go from there. Ms. Kraus, anything else we need to address on this file today?
No, thank you.
All right, thank you. Both parties are free to discuss.
I have a question.
Yeah.
Hi. We did all the paperwork. If you can go all the way back to the 2020, it was actually because of COVID, it was pushed back. So I believe that, everything that he gave, I have the paperwork that he put, how much he makes and everything like that. And I understand that there's the two other kids that he has to take care of. I understand that fully. Obviously, that's something that he has to take care of, but he also has our child that he has to take care of. And I feel like that amount that he's contesting is actually the right amount for it. It's actually less because it got pushed with the COVID. My case was not heard for like pretty much 2 years, I believe so. And he hasn't paid anything. And we, everything that all the question that, all the paperwork that the court asked me to do, I gave everything that I have. And I haven't even done any kind of, it's been my son is 10 years old now. The last time I did the very first time, he was 3 or 4. So his actual amount is actually more than what he needs now. He needs more. It's just I'm not even doing that. And that's why I don't know, like, if this does not, 30 days from now, if it doesn't go, do I get any kind of paperwork that we are doing another hearing?
Yes, you'll be notified of that next hearing, and you'll be able to appear as you have today. And, my point to Mr. Duchesne is, as far as the court's concerned, the amounts are correct and everything's been done correctly. If he can bring forward some kind of evidence through his motion that it hasn't, then we'll have to take a look at that. But as it stands right now, it's not going to change unless, the burden's on him to come forward and show that something has been done wrong or calculated incorrectly.
Yes, Your Honor. And then also the, what is it called? The amount for the next 30 days, is it just the rest of the 24 or 2,500 that he owes not to be on contempt?
Right now, the court's requiring him to make the normal monthly payment and provide the information. If he doesn't do that, then the court will proceed with contempt.
So it's the regular monthly payment that he owes.
Right. What I'm trying to do right now, Ms. Nolasco, is keep some money flowing to you. If that doesn't happen, then at that point, again, we'll proceed with contempt and the court will likely order jail time for Mr. Duchesne. What I'm trying to do is just keep some amounts flowing to you. And, because that's going to do you more good than him staying and being in jail. But if he doesn't pay, then if he's not paying, then there's no reason not to put him in jail. So the idea here is,
I understand.
Yeah. Okay.
Yes. Okay.
All right.
Okay. And then also that the 1,000 that he pays, is it something that's coming to me, or is it for the court?
Ms. Kraus, can you address that? It should be going to you.
Yeah, it would take 3 to 5 business days. There should be something coming down, but it's not going to happen today.
Okay, sounds good. Thank you so much.
Okay, thank you. All sides are free to disconnect on this case.
Thank you, Your Honor.
Plaintiff has a support obligation of $197 and the total amount due is $9,715.16, which includes this month's obligation. There has been no payment since the last hearing when the plaintiff was found in contempt and served 45 days in the Otsego County Jail and was released on October 9th. The last payment that was received was from a prior income withholding in the amount of $206.47 in February of 2024. There has been no communication with the plaintiff.
Thank you. Mr. Hildebrandt, was there anything you wanted to say in regard to this matter?
Not regarding the support, but I do have a couple questions, otherwise.
Okay, what are your questions?
It's actually about Chelsea's mental health records to further diagnose my daughter and the issues that she's got. I was just curious how I go about getting those, because I know they've been brought up in court before, but just, I don't know how the proper channels to go through to get that. I was looking if you could probably provide me a little guidance on that.
Are they documents that have been admitted as part of prior court proceedings as exhibits?
I believe they were. I know they were brought up and discussed in court, and that gave, when we were doing our custody here, that gave Bill's lawyer the opportunity to bring them up and discuss them in court.
Okay. Ms. Kraus, I saw you kind of nodding your head. Was there anything that you wanted to add to this?
Yes, it is brought to my attention that the plaintiff is actually in Otsego County Jail as of yesterday. I didn't check the inmate list this morning. I apologize.
Okay, all right. Okay, so Mr. Hildebrandt, to answer your question, first of all, if those are part of the court file, you can come to the clerk's office here in Otsego County and you can go through the file. If those records are part of the file, like if they've been admitted as part of prior hearings, then that's a public file. So you're more than welcome to come in and see what is in the file that you could review. To the extent that they're not part of the file, that is something that would require me to give you legal advice. I can't ethically do that.
Okay.
So you would have to gather some more research on your own, or maybe consult an attorney as to how you would be able to obtain those records.
Okay.
Because they're covered by all kinds of different protections regarding confidentiality and so forth. That doesn't mean you wouldn't have a way to get them. It would be something that you would have to consult an attorney about or research.
Okay, thank you, sir.
Okay. All right. In terms of going forward, although we do have that additional information, the court's going to issue a bench warrant for Ms. Brink. Since we do have her lodged already, Ms. Kraus, I think what we'll try to do is set that for a arraignment hearing on Wednesday when I have my criminal docket. Mr. Hildebrandt, did you want to be present for that?
Yeah, please, if I could.
Okay. When we get the date and time of that, we can contact you. Ms. Kraus, do you have Mr. Hildebrandt's contact information?
Yes, we should.
Okay. So Mr. Hildebrandt, we'll let you know the date and time, but I'm going to try and get that on the docket for Wednesday at some point, and you can join by Zoom as you're doing today.
All right. Thank you. Yes, sir.
Okay. All right. Thank you. You're free to disconnect at this time, Mr. Hildebrandt.
All right. Have a good day.